morning. Welcome. Good afternoon, you're right. Welcome to the National Constitution Center. My name is Lana Ulrich. I'm in-house counsel here at the center, and I'm delighted to be moderating this program today with Amanda Tyler, author of the new book, Habeas Corpus in Wartime, From the Tower of London to Guantanamo Bay. Before we begin our program, I just have a few housekeeping announcements. This Thursday, in partnership with the American Philosophical Society, Andrew O'Shaughnessy, historian and vice president of the Thomas Jefferson Foundation at Monticello, will be here for a wide-ranging discussion about Thomas Jefferson and education. On Thursday, June 21st, former Deputy National Security Advisor Ben Rhodes will be here to talk about his new book that delves into the most consequential and controversial moments of the Obama presidency. And members of the Constitution Center receive free tickets to our popular daytime programs and discounted tickets to our evening programs. If you're interested in becoming a member, please stop by the membership table in the Kirby lobby right outside of the auditorium here. Okay, and now for the program. I'd like to introduce my guest, Amanda Tyler. Amanda Tyler is professor of law at the University of California, Berkeley School of Law, where her research and teaching interests include the Supreme Court, federal courts, constitutional law, civil procedure, and statutory interpretation. She was previously a member of the faculty of the George Washington University Law School and has been a visiting law professor at Harvard, NYU, and the University of Virginia. In 2017, she was visiting senior fellow in the Law Department of London School of Economics and the Order of the Coif Distinguished Visitor. She previously clerked on the Second Circuit and for Justice Ginsburg on the U.S. Supreme Court. Please join me in welcoming Amanda Tyler. Okay, Amanda, we are here to talk about your new book. And for those of us, or those in the audience who may not be familiar with this topic, maybe we can start off simply. What is this concept of habeas corpus? What does it mean, and where does it come from?
So the roots of the privilege of the writ of habeas corpus come from England, as so much of our law does. And translated loosely, it is a phrase that references to undergo and receive the body. And translated further still, what that means is the writ of habeas corpus is a remedy, or I should say a writ by which courts take jurisdiction over the body of a prisoner. And in classical form, in the form of habeas corpus about which the book is written, we're talking about executive detention in wartime. We're talking about the king taking a prisoner and putting the prisoner in the Tower of London because the king decrees that this person is a bad person. And the court then taking jurisdiction to ask the custodian or the jailer why this person is in jail, and then demanding some explanation. Mm-hmm. In your book, you, in the beginning, explain how you became interested in this topic. You were mooting the counsel for petitioner in the Supreme Court case Hamdi v. Rumsfeld, and we can talk a little bit more about that case later, but I was just wondering if you could tell us a little bit about that experience, and how did it prompt you to writing a series of articles and eventually an entire book about this topic? Right, so before I became a professor in practice, I had the privilege of mooting the federal public defender who argued what is an incredibly important case arising out of the war on terrorism, Hamdi versus Rumsfeld. He was amazing, and it was a fascinating case to play a very, very small part of. But it got me incredibly interested in these topics, and I went and watched the case be argued at the Supreme Court, and at that point, I thought, there's some problems here. And the main problem is there were all these arguments about whether the president could hold an American citizen as an enemy combatant during the war on terror outside the criminal process, and no one was talking about history. And it occurred to me, surely this is not the first time in American or English history that we've been at war and the president has wanted to take prisoners, and we've needed to have a discussion about what legal framework governed the choices that were available to the executive. And so that started me down this path, which eventually culminated in writing this book to try and tell that whole history.
Mm-hmm. A lot of the book, or a good portion in the beginning, is indeed the English history of habeas corpus. And you quote John Marshall, who said that we need to understand the privilege's origins in English law in order to understand ours. And you explain how the history dates all the way back to even the Magna Carta, but also this important English law, the English Habeas Corpus Act of 1679. Could you tell us about those laws and how they are the roots of the habeas corpus privilege here in the United States?
Right, so John Marshall said in dissecting the suspension clause, which is the habeas provision in the United States Constitution, the terms that were used here were terms that were well understood, deriving as they did from English tradition. And so for people who were well versed in the English legal tradition, the people who wrote our Constitution, they knew that backdrop and they knew that framework, and that very much informed how they thought about these concepts. And as the book argues, the crucial sort of foundation for all of this was, in fact, the English Habeas Corpus Act of 1679. And why it's so important is because the act really reined in the executive, reined in the crown in a way that the common law writ of habeas corpus had not been able to do. So in the period leading up to the act, there are a number of famous cases that I talk about in the book, like the case of the Five Knights that arose out of Charles I's reign when he wanted to continue the 30 Years' War but had been cut off by Parliament. So he went around to the nobility demanding that they loan him money. Of course, it's not a loan if it's under pressure from the king, and several knights refused, and so he threw them in prison. And they argued, with the able assistance of John Selden and other notable English lawyers of the time, that Magna Carta and the common law writ of habeas corpus did not allow the king simply to throw people in prison because he thought they were bad guys, as it were. And the argument ultimately lost in the face of an argument made by the Attorney General at the time that the king is the font of all law and justice. And so if he says something, that is your due process, effectively. If you fast forward several decades in the 1600s, in the wake of the English Civil War, we find a parliament that is taking away power from the king and is growing in its power and taking control of a lot of things that the executive had used to be in control of itself. And one of many statutes that fall under the umbrella of this rise of parliamentary supremacy is the English Habeas Corpus Act. And it's enormously important, both to the direction of English habeas law as well as American habeas law, because among its most important provisions, Section 7 required the king, when he took, or the queen, when they take a prisoner, even if that prisoner was accused of committing treason, they had to be tried within 2 terms. That's 3 to 6 months. And if they weren't tried, if they weren't afforded a timely criminal prosecution and trial, judges on the royal courts were commanded by the act, under possible penalty if they disobeyed the act, to discharge the prisoner. The translation is the king could no longer hold people on suspicion alone. The king had to try people in due course, or they could run into the royal courts and demand their freedom, which they were given.
Mm-hmm. So if you were thrown in the Tower of London, could you file a habeas writ after this act had been passed and try to get your freedom?
Yes, so the way the Habeas Corpus Act worked is just that way. You would go before, often the Court of King's Bench, and invoke the act as a subject of the crown, say, I get the benefit of this act, I haven't been tried, I have to be released. And there are many cases in which the Court of King's Bench ordered the release of prisoners, including very prominent prisoners, on this basis. And so you could see that this is a really powerful check on executive authority, and specifically executive detention. It's going to be a problem. It's so powerful. Because in short order, this is 1679, by 1689 we've seen the Glorious Revolution, and William has taken the throne, but the Jacobites are quickly regrouping and trying to reinstate the Stuart line on the British throne. So there's treason at every corner, and Parliament has to do something because the king comes to them and says, I know people are plotting my demise, I want to arrest on suspicion, but I also know that if I do that, they will be released under the Habeas Corpus Act. That's where suspension comes from. Parliament invents suspension. It took only 10 years. And the idea behind suspension is to temporarily displace those protections and to empower, and this is what all the English suspensions did by their terms, empower the executive to arrest on suspicion, including suspicion of committing treason. And so we see, on the one hand, this great check on executive authority, but on the other hand, very quickly, the invention of a concept that, again, re-empowers the executive to arrest solely on suspicion and arrest and detain outside the criminal process. That's the suspension framework. That's what our suspension clause was written against, and that's the model on which it was based.
So around the time where that the American colonies started fighting back against the king, did habeas apply in the colonies, and if so, did Parliament have to suspend it, or how did that work?
So this is a really important part of the story of the American Constitution, and this part of it, but the larger Constitution as well. It did not apply here, and that was enormously controversial. A number of states, including prominently Massachusetts and New York, had attempted to adopt the English Habeas Corpus Act as their own. They wanted the trial by jury, they wanted the English Habeas Corpus Act, and it's no surprise that they wanted it. The founding generation, particularly as we get closer to the American Revolution, they are heavily steeped, and these books are up in the display, actually not upstairs, on the same level here. They're heavily steeped in William Blackstone's commentaries and Henry Kerr's treatise, and they're reading these sources on English law about how great the English Habeas Corpus Act is. So Henry Kerr put it on par with Magna Carta and the English Bill of Rights as one of the greatest protectors of English civil liberties. And William Blackstone called the English Habeas Corpus Act nothing less than a second Magna Carta. So the American founding generation, they're reading about these wonderful protections and civil liberties that Englishmen enjoyed in England, but they're being denied them here in the colonies. When Massachusetts and New York attempted to adopt the Habeas Corpus Act as their own, they met with a royal veto. And the king said, those protections do not apply in the colonies. And so as in the lead up to the American Revolution, what we see is a lot of evidence that this was a really big deal to the colonists. So the Continental Congress in 1774 complained about the fact that the Americans had been denied trial by jury and denied the protections of the English Habeas Corpus Act. And they label the British government as an arbitrary government for that reason. And this is a part of the story of how revolution begins to brew. And then to highlight how the geography of this worked, during the American Revolution, what we see is a number of prominent American prisoners being brought from here to England. And a couple of stories in particular, and I could tell one to highlight this, really lay out how this framework worked. So Ethan Allen and his Green Mountain Boys were fomenting their own revolution up north, and they attempted at one point to take Montreal. Now, they didn't have a particularly well-oiled plan going into it, and they were quickly captured. And he and the Green Mountain Boys were put on a ship and sent to England, and surely they went over some long journey. They arrive in England, and they are only there for less than 2 weeks before they are ordered to be put back on a ship and sent back to the Americas. Now, I've puzzled over that. Why would you go to all that effort to bring them over to England only to turn around and send them back? The answer is because of this legal framework. Prominent lawyers with ties to the American cause who had successfully represented an American in the months leading up to Allen's arrival in habeas proceedings, and it had invoked the Habeas Corpus Act, they had taken on Allen's case. And the administration knew this. And they knew the lawyers would invoke the English Habeas Corpus Act. And because Allen, as an American, was considered a traitor, and by that a subject of the crown, he could claim the protection of the English Habeas Corpus Act and demand his release if he wasn't tried. Now, trying him would raise a number of complicated issues because there were people in England who were sympathetic to the American cause. And so rather than have to deal with that legal framework, the easy solution was to put him back on a ship and send him back to the Americas, where the English Habeas Corpus Act didn't apply, and he could simply be held as the equivalent of a prisoner of war. But as the war unfolded, more and more American prisoners are brought to English shores, and that solution can't be the way that they handle it going forward any longer. So what does Parliament do? They take a history lesson, and they pass a suspension. So Lord North goes to Parliament and asks for the power to hold American traitors like other prisoners of war. In other words, he says, we need to hold these people in detention for the duration of the war on English soil. We can't and don't want to prosecute them, and indeed that's in the prelude or the preamble to the act. Because we can't prosecute them, we need this authority. We need to give the Crown this authority. And so suspension winds up controlling for most of the American Revolution, and some 3,000 American prisoners are held in England under the suspension as the war unfolds.
It's interesting that that was such a prominent cause of behind the revolution, and yet when we win and we draft our own constitution, the way we phrase habeas is in the negative. Basically, it's the suspension clause. Can you tell us a little bit about the drafting process and how did we come up with that formulation and why is it in the negative? And were the Anti-Federalists right to be concerned about that?
Right, so the phrasing and the way the suspension clause was included in the original body of the Constitution raises a host of really interesting questions that tie into the larger debates about the Constitution at the founding. I think some really important things to keep in mind, among others, are that the suspension clause precludes the government from suspending the privilege of the writ of habeas corpus except in cases of rebellion or invasion when the public safety may require it. That's a really important constraint. The English model did not have it. Of course, all of the English model is derived from legislation. So right away, the decision to constitutionalize this model is itself significant and to put it into a binding written constitution, no less. But going further, I think in large measure because they had lived through a suspension during the Revolution and they knew how just very dramatic suspension was, empowering the executive to hold outside the criminal process, the founding generation was very worried about it. And indeed, 3 states voted against recognizing any suspension power in the Constitution at all at the convention. And for that reason, they put in place these constraints, that there had to be a rebellion or invasion. Now, where that came from is a good question. And I don't know the answer exactly. I know it comes from the original wording of the first suggestion for a habeas clause that was made early in the convention. But where that came from, I don't know. I suspect that it might have come from the Irish Habeas Corpus Act, which was enacted just years before the convention and included a similar constraint of requiring a rebellion or invasion to suspend. But going to your question about the phrasing of the provision, it's right, it doesn't outright guarantee us the privilege of the writ of habeas corpus. It says it shall not be suspended. And I think to understand that, you have to understand the way the law worked at that time and the way the Constitution was understood to operate. It was an overlay on all the ongoing law that we had taken from England and put into our state's jurisprudence, our state law. And so I think there was a working understanding that the privilege would be available either as a matter of state law or if for some reason not available there, it would very much be guaranteed despite the phrasing in the suspension clause. And a lot of conversation in the ratification debates very much backs up that conclusion. There was a working assumption that the privilege would be available. But it did provide fodder for the larger debates between the Federalists and the Anti-Federalists over whether we needed a Bill of Rights. And indeed, that debate played out early on between Jefferson and Madison, who wrote letters back and forth about the suspension clause. And Jefferson wanted it worded in a much more protective fashion, which is very interesting because he winds up being the first president to propose a suspension to address the Burr conspiracy. But he wanted a much more forceful language. Madison was skeptical. He was very skeptical, as you may know, about a Bill of Rights in its entirety. And here his skepticism played out. He said, no matter how we phrase it, it's going to be the case that if things get bad enough, people aren't going to care what's written down and what they're supposed to believe and abide by. So it's an interesting window into that debate. As it unfolded during the ratification debates, many detractors pointed to this as evidence that there was a need for a Bill of Rights because the suspension clause clearly empowers the government to do something very dramatic. And so there was a concern that without a written Bill of Rights, there would be too much power given to the central government. And this was example A as to how that would work. So that was a big part of that debate. But in the end, how it played out is quite interesting because even those who were clamoring for a Bill of Rights and complaining that this was an example of why we needed it. At the same time, they pointed to the suspension clause and they said, this itself is a partial Bill of Rights. And the federal farmer called it a good start. And later, John Marshall would also refer to the suspension clause as a partial Bill of Rights. So it was a really important component of the original Constitution.
I thought an interesting fact that you discuss in your discussion of the Constitutional Convention was that originally it was located in Article 3 instead of Article 1, which is the legislative branch. And I was just curious, was there any significance for that? And what would have happened if they had left it in Article 3? I mean, how might that have worked?
Well, I think the major point of significance with respect to the original placing of the clause is that it was put next to the jury trial right. And that shows you just how intimately connected the two provisions were. The jury trial right is the right to be judged by your peers through the criminal process, and that was completely wrapped up with the suspension clause and all the protections that had long been associated with the English Habeas Corpus Act. And so that's what's significant, I think, about that placement. It winds up getting moved in the restylization and reorganization, which was not supposed to have any substantive component to it, to Article 1. And there it also finds a natural sort of companion. It's next to the Bill of Attainder clause, which prohibits bills of attainder. And the other workaround to the English Habeas Corpus Act traditionally had been through bills of attainder. So it fits quite nicely there as well.
Great. So after the Constitution's ratified and we have the suspension clause in place and we have the Bill of Rights, the Due Process Clause, what are some of the first times that the President or Congress decide that they want to think about suspending it? After the Revolution, were there any flare-ups or conflicts that kind of caused the government to say, okay, maybe we should think about suspending it here?
Yeah, so I think what's really interesting is early on the answer is no. The answer is no until Jefferson. Washington had to deal with the Whiskey Rebellion. Adams had to deal with a rebellion as well. They didn't, from everything I've seen, even consider suspending habeas. They called up the militia. Interestingly, George Washington had to ask James Wilson's permission to call up the militia under the Militia Act that was then controlling. This is a fascinating sort of tidbit from this period in history, to have the president have to turn and ask a Supreme Court justice to certify conditions were bad enough in Pennsylvania to call up the militia is a truly extraordinary thing. Imagine if we had to do that today. That would be quite something. But he didn't even consider suspension, and he ordered his military commanders that they were immediately to turn over anyone captured to the civilian authorities to be dealt with in the ordinary course in the criminal process. So that's a great start. That's an incredible model of working within the law and not thinking about invoking these extraordinary emergency powers on the part of Washington. That model breaks down very quickly when we get to Thomas Jefferson, who, for better or worse, thought the Burr conspiracy was a very big deal and went to Congress and requested the first suspension on a federal level. Interestingly, the proposal sails through the Senate. I mean, absolutely sails, and it runs into problems in the House. And there are really fascinating debates that unfold during this period. The House members knew their history. They invoked Blackstone, they invoked English legal history and political history, and they said, this is not even close to what the founders had in mind when they were talking about invoking this power. And you can only suspend, they say, in the most dire of circumstances when the country itself is in jeopardy. And that's what we see later when we jump ahead in the Civil War, when we finally do get a suspension. But the early cases, we don't see it. And so it fails. The Jefferson proposal fails in the House. And interestingly, there were prisoners in custody at the time that these debates were unfolding. And they were in military custody. And very good lawyers had sought habeas writs on their behalf and argued they can't be held in military custody. And the minute the suspension fails in the House, Jefferson's administration realizes we have to charge these guys with a crime and we have to turn them over to civilian authorities. And that's what they did. They worked, again, within that framework.
You mentioned Lincoln's infamous suspension during the Civil War. I think most people, or if they're familiar at all, they're familiar with that. And another interesting tidbit I learned from your book is that not only Lincoln dealt with suspension, but so did Jefferson Davis. Yet Jefferson Davis did not act until the Congress acted, whereas Lincoln obviously suspended it himself and then later had to wait until Congress basically passed legislation after the fact authorizing that. Why did they have different interpretations of that, and where did that come from?
So I think that's a really interesting comparison, and it was something that I had a lot of fun with in the book. Jefferson Davis ran on a platform of criticizing Abraham Lincoln as trampling on civil liberties, and in particular pointed to the fact that Lincoln had suspended habeas eventually on his own nationwide. Of course, 5 days after Jefferson Davis gave his most prominent speech making this very argument, his Congress, I believe at his behest, suspended habeas in the Confederacy. So they were both wartime presidents, and it was the war, it was an extraordinary war, and so it's not surprising that that's where we see suspension. What is interesting is that Lincoln does get out ahead of his Congress, and then you wind up with a little bit of a chicken and egg problem because he's gone ahead and done it, first in small geographic pockets, but eventually on a nationwide basis. The Congress sort of drags its feet, and it indulges in the luxury of debating whether suspension is warranted for almost 2 years. So there, I say in the book, I think there's plenty of blame to go around for forgetting the model, but I definitely say that I think Lincoln was wrong to suspend on his own. I don't think the Constitution envisions the president having the power to do this on his own. That's very hard to square with the English backdrop that established this framework. This framework comes out of Parliament taking power away from the president, or the crown, excuse me, and trying to control the executive and check executive power. So as Chief Justice Taney, who one always cites and quotes carefully because he wrote Dred Scott, he's not one of our great Chief Justices, but he had a case in front of him called Ex parte Merriman that involved this very issue, whether Lincoln's unilateral suspensions were lawful. And he correctly held, in my view, that they were not. And he said, I think quite poignantly, that if Lincoln is right, if his argument is right, he's been given more power than the Crown enjoys under the English Habeas Corpus Act. And surely that's not right. Surely against the backdrop of how this country was formed and our suspicions about centralized executive power, that just can't be right.
Wow, that is powerful, yeah. Well, Congress does authorize suspension a little bit later to President Grant to help combat the KKK in the South. Was that done in what your view is the proper procedural means underneath the Constitution, and how did Grant use that power?
So that's another interesting part of the story of suspension that I think a lot of people don't know. We think about it, and we should, as a dramatic emergency power that is, generally speaking, at odds with civil liberties. It is a very dangerous power, and we should underscore that without question. But one of the important suspensions, and there have only been a handful in American history, was in fact done to promote the cause of civil rights. President Grant went to Congress and said things are out of control in the South. The Klan has taken over law enforcement and all kinds of things. They are terrorizing various areas of the South and preventing enforcement of the laws, and I need more power, and I stand committed to promoting the Reconstruction Amendments and making sure that the words written on the paper are real. But I need emergency powers to do that. And so Congress gave him the authority to suspend, and he exercised it in a very limited fashion in small pockets of South Carolina. And the idea was to round up everyone who was suspected of being in the Klan and try and regain control of the region and allow people to live freely and safely and start to enjoy the Reconstruction Amendments. When we look back on that, I think one of the questions that should be asked is whether he went far enough, because very quickly the suspension was allowed to lapse and the Klan basically regrouped and went back to its old ways. So it's an interesting episode that shows the power of suspension, but also its limitations, I think.
Right, you write how Grant was very careful in exercising his power after Congress suspended that. Yeah. So I think the next major conflict or incident in which maybe suspension should have been, or the privilege should have been suspended is during World War II. And you talk about the endo case in Korematsu, in which Japanese Americans who had been interned were challenging their detention. And so can you talk a little bit about what was going on at World War II? And did anybody in the government say, hey, we should be suspending habeas here, or maybe this is not constitutional, or what were the voices inside the government with respect to this policy of internment?
So World War II is a fascinating case study of how all these issues come into conflict. And then eventually what we wind up with, to borrow a phrase that I use in the book, is a forgotten suspension clause. And it's really a tragedy. So this model, at its core, says the government cannot detain people who can claim the protection of domestic law, principally citizens, but in some cases this sweeps beyond citizens, outside the criminal framework on suspicion of treason or anything else. And that begs the question, if that framework was so well established that Abraham Lincoln believed he needed to suspend habeas in order to hold Confederate soldiers without trying them for a crime in the midst of the Civil War, if that was the framework, how is it that our country interned over 100,000 Japanese Americans, over 70,000 of whom were American-born citizens, for an average stay of 3 years in so-called relocation centers in the West? That question, I think, is an important question to be asked, and the answers that I uncovered in my research are really quite distressing. There was a suspension during World War II, but it was only in the Hawaiian Territory. There was no suspension in the West Coast. And in the wake of the bombing of Pearl Harbor, very quickly military officials started suggesting the policies that eventually were put into place, including policies of interning Japanese Americans. And what is remarkable about the very early weeks as these debates are unfolding, so December 1941, the bombing of Pearl Harbor, declaration of war. January 1942, this debate is unfolding. February 1942, we wind up with Executive Order 9066 issued by FDR, which then sets in motion all the military regulations that then follow. In that pivotal month of January, the Attorney General of the United States, Francis Biddle, said to members of Congress, said to the President, said to the War Department, you cannot do this unless you suspend habeas. You cannot hold American citizens this way without a valid suspension of habeas corpus. And the Secretary of War clearly understood this as well. He had moved prisoners between the mainland and Hawaii to work within the suspension framework. Other members who reported, or advisors, I should say, who were advising FDR during this period told him the same thing. People understood this, and these were highly trained lawyers. Biddle and Stimson, the War Secretary, had been trained at Harvard. They understood this historical framework, and they understood what its implications were for the policies that were being proposed. But ultimately, as I talk about in the book, there's a quote from a War Department official from a debate that waged between the War Department and the Justice Department in January that I think really encapsulates the mindset that controlled during this period. He said something to the effect of, well, if it's a question of the safety of the country, the Constitution, well, it's just a scrap of paper to me. We have to protect the country at all costs, in other words. And that, I think, was the mindset that ultimately came to control during this period. The Justice Department sort of recedes, the War Department takes center stage, the President issues 9066, giving effectively, to quote that same War Department official, carte blanche to the military to do whatever it wants in order to protect the West Coast. And then we see the policies of evacuation, registration, assembly, and reporting to the relocation centers put in place over the next few months. 4 important Supreme Court cases come out of this. Korematsu is the one that we teach our students in law school, that everyone knows best, and we teach it as wrongly decided. But there's another case, and it was, but there's another case that's also really important out of this period that we don't teach, and I think we should be teaching, and it's called ex parte endo. And the endo case is really extraordinary. Endo is a woman, Ms. Mitsui Endo, who worked for the state of California in Sacramento. And like all Japanese Americans, she was summarily fired by the state in the wake of Pearl Harbor. So she and her family report to an assembly center. Meanwhile, a lawyer named James Purcell had been doing a lot of work for the Japanese American Citizens League. And he went to meet with one of his clients at one of these assembly centers. And it was a horse racing center. And the government had whitewashed the walls of the horse stalls without cleaning them first, had just painted over the horse manure and other things that were on the floor, and they had put a family in each of the stalls. Now, Purcell's interesting because he was the son of a prison guard at Folsom Prison. And so he had grown up on the grounds of a high-security prison in California. And he went to see his client at Tamfram, and he said, "This is unbelievable. The government is housing people who have committed no crime in worse conditions than the prisoners at Folsom. I have to do something about this." So he had been brought in to represent the fired California employees, and he used a survey to those employees to pick Ms. Endo as his great model habeas petitioner to challenge the policies outright, and in particular to challenge the internment outright. And her case is the only case that outright challenged the internment. And he could not have picked a better litigant to represent her cause because the government realized the threat that this case posed, and so they offered her release. They had done this in cases coming out of Hawaii with great success. If the prisoner is released, going back to the very first thing we were talking about, the court loses its jurisdiction over the case. There's no body for it to exercise jurisdiction over. And so the government had offered Ms. Endo release in order to moot her case, in other words, to make it go away. And she refused, and she stayed in the camps almost 2 more years. And she did all this meanwhile while she'd been separated from her parents, and her brother was fighting for the United States Army. Her case eventually gets to the Supreme Court, and her lawyer argued, he relied on the suspension clause, he relied on the famous Civil War case of Ex parte Milligan to say the government cannot do this. The government cannot treat its citizens in this way, as though they are wartime enemies from another country. That's what the court said in Milligan, that's what the suspension clause says, and the government just can't do this. So there was a great opportunity for the Supreme Court, after all the missteps leading up to this point, to settle the issue and say, yes, this was unconstitutional, this was a violation of the suspension clause. And what's also interesting about this is 1944. It's not until 10 years later that the Supreme Court recognizes that the Constitution and its equal protection clause apply to the federal government. So although discrimination had been argued in Korematsu and Hirabayashi, Yasui, and in this case, those arguments were a dead letter at that point in time. But this argument was not. Nonetheless, the court did not decide the case on constitutional grounds. Because the government had conceded that Ms. Endo was loyal and law-abiding, the court concluded that she wins her case because it interpreted the military regulations not to allow the government to continue to detain so-called loyal citizens. Now, what's interesting about the case is I think it's really a missed opportunity for the court to decide the important constitutional issues at stake. They instead go off on a tangent that can't be squared with the historical model and all that this framework was intended to accomplish. They do give her a victory in the large, real sense, insofar as the court held up the opinion to tip off the White House that it was going to come down and it would be portrayed as a loss. And so it waited, and the White House, getting ahead of the opinion, finally decides to announce that they're going to close the camps. FDR had resisted his advisors who'd been telling him to do it, but at this point, finally, he capitulates and says, okay. And so the camps are announced that they will be closed, and the decision in Endo comes down the next day. So it's important to keep in mind that it is a big victory in that very real, tangible sense, but not in the long-term precedential sense with respect to constitutional law.
Wow, yeah, that is a very powerful story. Two questions. So does endo still have significance today? And had Congress suspended habeas, would it have been okay for the government to do that? I mean, would there have been no legal challenge to that, basically, as disturbing as it may seem?
So I'll take the second question first. There were some who proposed at the time, very aware, as many government officials were, that this violated the suspension clause. There were proposals that a suspension should be adopted, that Congress should take up the matter and suspend. My view is that it would not have been a legitimate suspension. I don't think there was a sufficient threat on the mainland to justify it. Now, others may feel differently, but I think that is the right conclusion. And I also further argue in the book that in either respect, I think that's a question for the courts. And this is also a controversial proposition. There are many who have argued over history that if there's a suspension, that's the end of it. The courts can't check to make sure that the underlying circumstances constitute a rebellion or invasion. But I think that's wrong. I think the courts have to be some kind of a backstop in this regard. Otherwise, we're giving just way too much power to the political branches to trample on the most basic of civil liberties. And I can't imagine the founding generation expected that things would operate that way. And indeed, there's evidence from the ratification debates to support the proposition that courts would check the exercise of this power. Now, in terms of the precedent that this established and what endo stands for, I would say more generally, the Japanese-American internment established a very unfortunate, obviously, enormously unfortunate historical precedent. But on this legal basis, it's also deeply unfortunate, because what is unfolded is you see the course of suspension clause jurisprudence, which is relatively consistent, with the only blip being Lincoln's invocation of the authority, but he clearly understood that he needed a suspension to arrest outside the criminal process. But for his separation of powers confusion, if you will, the law of the suspension clause is relatively consistent until World War II. And then the internment sort of gets it off the rails. And what we see in modern cases, in the War on Terror and in more recent events, is now a modern legal and political acceptance of the idea that you can hold an American citizen outside the criminal process on suspicion alone in the absence of a valid suspension. And that is deeply troubling, because that is directly at odds with what the founding generation thought they were accomplishing in ratifying the suspension clause.
Mm-hmm. Right, so this is the backdrop then to what's going on today with the War on Terror, the enemy combatants down at Guantanamo Bay, and this Hamdi case that we mentioned at the very beginning. Can you tell us a little bit about Hamdi? How did the case come about? Who was Hamdi? And what did the court hold when it evaluated his habeas petition?
So Hamdi is an American citizen. He was born here. He grew up elsewhere. He was captured in Afghanistan and initially brought to Guantanamo Bay, at which point the government learned that he was a citizen, and they transported him to the mainland. His father, as his next friend, brought a habeas petition on his behalf, arguing that his detention was unconstitutional and making many of these arguments. The Supreme Court ultimately holds that the government can detain him as a so-called enemy combatant. Now, the decision is interesting, and how it will hold up over time remains to be seen, because it's a decision that resulted from a very fractured Supreme Court. You have Justice Sandra Day O'Connor write for 4, and Justices Souter and Ginsburg join her judgment, as they say, solely to make a court. But in announcing his concurrence, which is something you rarely see at the Supreme Court, Justice Souter made clear that he and Justice Ginsburg did not necessarily agree with the constitutional conclusions in Justice O'Connor's opinion. But they did ultimately sign on to a line that says there is no bar to this nation holding one of its own citizens as an enemy combatant. And that holding controlled the day. All of this was up against a very powerful dissent that paired Justice Scalia with Justice Stevens. Now, you don't often see those two standing out alone together. And so, as I tell my students, when you see a lineup like that, you better sit up and take notice because something important is going on. And what's going on is they both recognized that the detention of Yasser Hamdi as an American citizen on American soil was flatly at odds with the whole history of the suspension clause. And so their dissent is a powerful history lesson that works through a lot of the major episodes that we've been discussing. The majority, or I should say, the plurality opinion written by Justice O'Connor does not even engage in these historical arguments. And coming back to your first or second question, I think it was, that's what prompted me to write the book, to tell more of this history, to uncover more of these stories, to highlight just how well entrenched this framework was and how important it was to the founding generation, to try and show that I think that decision was wrongly decided. And my hope is in time that this work and the work of others will help highlight that and will give the court an opportunity, if such a situation, if such a case were to come before it again, to sort of right the constitutional ship.
Mm-hmm. Great. So we have a couple audience questions. We'll try to get to as many as we can. One does ask about the prisoners down at Guantanamo Bay, and can you discuss the extension of habeas corpus to them, maybe those who are even non-citizens as well? And I think this is referring to the Boumediene case.
Yeah, so more difficult and complicated questions have continued to arise as the war on terror has unfolded, and the biggest one is, what do we do with the people who are at Guantanamo Bay? And more specifically, what is the role of the Article III federal courts in reviewing those detentions? This is a really hard question, and one of the reasons it's so hard is because if you want to look to history, and not everyone does, but most people who are doing constitutional law start with history, and then the question is where they go from there. If you want to look to history, there aren't great analogies to be drawn between the situation of those who are at Guantanamo Bay and classic war models. So in the American Revolution, there were clear lines of division between American prisoners who were traitors and could claim the protection of English law, whatever those protections were, and that depended, as we've discussed, on geography. But for the French who were helping us, when they were captured, they were prisoners of war, and they were governed by international law. Their rights and obligations were governed by the law of nations. So there were two legal frameworks in place, and depending on whether you were in a declared state of war with Great Britain, you fell into one category or the other, and depending whether you were a traitor. Now, the Guantanamo Bay detainees who've been captured as part of this war on terrorism, they don't fit that model because they come from countries with which we have not been in a declared state of war. And so the classic model doesn't work. And by the time the case gets to the Supreme Court, Boumediene, the Supreme Court has also faced the fact, or the backdrop, that the Bush administration had largely, though not entirely, disclaimed the application of a lot of international law to Guantanamo Bay. And so against that backdrop, I think it's unsurprising as a descriptive matter that the Supreme Court felt compelled to extend the suspension clause to encompass challenges brought by the detainees at Guantanamo Bay, to enable them or empower them to go into federal court and argue that there was insufficient evidence to support the proposition that they were enemy combatants. And those cases have unfolded in the DC Circuit ever since, and they're still ongoing. That, I think, can be defended arguably on two bases. One, you could defend it as an extension of the suspension clause that sweeps beyond this original core that we've been discussing throughout. Or two, you could defend it as a natural application of modern due process jurisprudence. Whether you support or do not support Boumediene, and on whatever basis you support it or do not support it, the main argument I make in the book is it's important that when we go off on this tangent, and Hamdi had a similar holding. The court said the government can hold him, but he can go into court. Well, actually, Justice O'Connor said he can go into a military tribunal and try and present evidence undercutting the government's argument that he's an enemy combatant. Both of those cases, I think, forget, and Hamdi in particular, what the core of the suspension clause was about, which was it wasn't about promising additional process. It was about actually constraining the kinds of detention the executive could undertake. And so even accepting Boumediene, which is good in many respects, it's important that the jurisprudence of Hamdi and Boumediene not be taken further to forget what the original core purpose of the suspension clause was. And so Justice Stevens, who I mentioned, dissented in Hamdi. He was in the majority of Boumediene. And I think how he would explain this, and I try to channel him a little bit in the book, is to say the Constitution provides a floor, and the original understanding is a floor, but not necessarily a ceiling. And I think that's how you can explain his votes. So it's very clear to him that the Constitution precluded the president from holding someone outside the criminal process who could claim the protection of domestic law in the absence of a valid suspension. Ergo, it follows Hamdi's detention is unconstitutional. But that's maybe not all the suspension clause did, and in Stevens' view, the Constitution evolves, and so maybe it has evolved to expand its protections to other places, to other categories of persons, to provide them with some process. And so maybe you can house all of that under the suspension clause. I'm agnostic about most of that. What I care about is that that core not be forgotten, because the wrong turn in all of this jurisprudence, as I've said, came during World War II. And that's a terrible precedent on which to lay modern habeas jurisprudence.
Right. So, out of curiosity, if you are an enemy combatant that's not taken right to Guantanamo Bay, but let's say you're detained by U.S. forces elsewhere, like at a black site or something, you don't have a habeas right, correct? Or is that not decided?
It's correct under the D.C. Circuit's law, but the Supreme Court has not answered that question. So in the wake of Boumediene, there was a challenge that came up through the D.C. courts having to do with one of the prisons in Iraq. And the question was whether Boumediene should extend to the prisoners being held there. And the D.C. Circuit eventually said no. But the Supreme Court hasn't answered that. Those questions are tied up with really hard questions about how far the United States Constitution reaches, whether it's a global constitution that constrains our government everywhere it operates. There's not a lot of case law on these questions. There are very few cases, and they're a little bit complicated, and so it's hard to know what the court would do. But there is the potential that the court will have to take up some of these issues, depending on another case that's currently pending in the D.C. Circuit, which involves an American citizen who is being detained as an enemy combatant in Iraq right now. And the case is called Doe versus Mattis, and we'll see what happens in that case. But it raises not the specific issues you highlight, but instead it's sort of the combination of Hamdi and Boumediene, because he's not being held on American soil, he's not even being held at Guantanamo, but he's a natural-born American citizen. So depending on whether the Supreme Court takes up that case, we may start to get some answers on some of these issues.
One question asks, how does habeas corpus in the United States compare with habeas corpus in other countries? And I know in the book in particular you do a sort of a modern comparison between the right here and how the right is in the UK now, especially with how they're dealing with the war on terror. Maybe talk about the UK, and then if there's any other countries where merits comparison to our system.
Well, as you can imagine, these issues are not unique. These legal problems are not unique to the United States. So it's a great question, because it's a question that countries around the world are having to confront. How do we deal with the detention of prisoners during wartime, and what are the legal ground rules that constrain or control, govern what the executive can do? In the United Kingdom, they have interestingly moved away from the model on which we based our Constitution, which is to say, to deal with the Irish Republican Army violence, they repealed Section 7 of the English Habeas Corpus Act. They put in place a regime which is quite interesting, particularly when contrasted with what we have under Hamdi. To be clear, what we have under Hamdi is a regime whereby our government can detain an American citizen as an enemy combatant. They get, arguably, on one reading of the plurality opinion, one hearing to contest their detention, and then they're probably held as an enemy combatant for the duration of the war on terrorism. The opinion is unclear as to whether there's a second review at some point. The English model is very different. They've adopted now a regime whereby, citizen or non-citizen, you can be held temporarily, but we're talking about a matter of days, 7 to 14 days, and you get multiple rounds of judicial review during that period, and then you have to be released if you're not charged with a crime. So they have one model now in place, and it came out of the IRA violence. And it provides the same protections for citizen subjects or non-citizens, and it provides rather robust protections in terms of judicial review. It does allow for that temporary detention, which is at odds with the classic model outside the criminal framework, but it's a very different model. We also see in other countries like Israel, where they confront these issues a lot, quite robust judicial review. So it's very different than the model that we have under Hamdi. The model that we have under Hamdi arguably is the worst of all the options.
Wow. So you think that the protections in the United States are a little bit weaker than in most other countries like the UK or in Israel or even elsewhere in Europe?
I think arguably yes.
Okay, well, we'll see if the Supreme Court decides to answer that question in Doe v. Mattis and see if maybe we start getting some of those protections back, at least for U.S. citizens abroad.
It's an interesting contrast if you compare the UK and the United States, because remember, we constitutionalized all of this. We put it in a written binding constitution, and that was supposed to be something that would last forever, as John Marshall said. And it's quite curious where we've wound up.
All right, I think we have time for one more question. This question asked about the Japanese internments during World War II, which I know we talked a little bit about. But I guess we want to maybe elaborate a little bit more about some of the lasting lessons that maybe we can take from either the history of habeas from the World War II era and apply it to some of the issues that we talked about that are percolating today. What should people learn from it? Where should we take away? And where would you like to see maybe the court go in the future when it looks at these issues?
So that's a great question. I think we can learn a lot from that historical episode, and there are a lot of lessons that come out of it that are very timely today. So the first is, if you look at speeches that a lot of Japanese Americans have given in the wake of their internment, they often quote Charles Evans Hughes in a speech that he gave before he went on the Supreme Court, where he talks about the Constitution, and he uses similar phraseology to the War Department official who I quoted earlier, but for a different end result. He says, the Constitution, you may think it's your protection, but it's only a scrap of paper. But he uses the phrase differently. He says, it's only as good as the people who stand behind it. And I think the lesson that we should take from that is that we all have to buy into the constitutional values that are in that document and that are enshrined in that document. And the failings of the World War II period occurred on just about every plane. So J. Edgar Hoover, the director of the FBI, who was himself no stranger to robust surveillance, even he was skeptical of the proposals. And he said, there's no basis for believing in widespread disloyalty on the part of Japanese Americans. This is the product of mass hysteria. And so tying that together, I think there's an obligation on the part of the American people to protect our constitutional values, to not look just to government officials to do that. And one of the great failings during World War II is that the American people, particularly in the West, did not do that. Going further, you have government officials who are saying and advising the president, this is unconstitutional. And yet the policies get rolled out anyway. That should trouble us. That should trouble us. We should demand more of our government officials. We should demand that they honor our constitutional traditions in making decisions. And on that score, a contrast that is quite stark can be drawn between President Roosevelt and Prime Minister Churchill. England had, or the United Kingdom had, as you might imagine, given how the war was impacting England, their own domestic detention policies. And of course, because the Habeas Corpus Act was not constitutionalized there, it was the product of legislation, it could be modified. And it was. And so they took into custody some 2,000 citizens over the course of the war outside the criminal process. Churchill initially supported this, but in the middle of the war, he turned against it, and he very actively started lobbying to close down the program because it was completely at odds with all of British and English legal tradition. And he talked about the important status of habeas corpus in that tradition. And he also said in writing to one of his ministers, I know this is a really popular policy. I know that if you stand up and lobby to end it, you will be unpopular. But he said something really poignant in a letter to his minister. He said, people who are not fit to defy clamor and go against the popular will are not fit to be ministers in times of stress. And I think that's a really powerful lesson to learn from this period, that sometimes, even in the worst of times, government officials have to stand up for our values, even if it means they make unpopular decisions. And then finally, I think the courts are important here. In the separation of powers and the constitutional structure that we have, James Madison and others talked, Hamilton in particular, I know there's a Hamilton exhibit here right now, they talked about the importance of the independent judiciary. And Hamilton talked about the judiciary as standing between the political branches and the people, to protect the people and make the political branches live up to their promises in the Constitution. And so there's an important role for the courts in all of this as well. And they did not live up to that role in the Japanese-American cases that they heard during World War II. But there's always hope that if something like this happens again, they can make it right.
Professor Tyler, thank you so much for being here.